Welcome to all. Today, as a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of introduction to IBC and the initiation of CIRP. Before discussing today's concept, let us recap what we have discussed in the previous class. So in the previous class, we have discussed the CIRP flowchart, whereby we have discussed how CIRP process will be initiated, that is from the application till the liquidation of the company. That is, when the CIRP process initiated, it can be initiated by either financial creditor, operational creditor, or corporate debtor. Then adjudicating authority will admit the application. Then subsequent to that, they are going to appoint the resolution professional. Then COC will be formed. Then subsequent to that, you are going to approve the resolution plan. If the resolution plan is approved, then you are going to implement the resolution plan, or otherwise you are going to go for liquidation of the company. So the flow chart we have discussed in the previous class. Then subsequent to that, we have discussed the governing sections, that is section 6, who can initiate the CIRP process, section 7, 8, 9 and 10. Then we have discussed in detail who can initiate and essentials to be established for admission of a corporate debtor. So whenever if you want to initiate the CIRP process against a corporate debtor, we have to satisfy certain essentials. So these essentials we have discussed in the previous class. Now let us look at the procedure. Okay, so till now we have discussed the section. Now let us look at the procedure in detail, how to make an application by this FC. So financial creditor under section 7 of the Act. So the application under section 7 may be preferred by any creditor. So either singularly or jointly. So the application can be made by the single creditor or application can be made by the joint creditor also. Okay. The form that is prescribed is in Rule 4 of the insolvency and bankruptcy application to the adjudicating authority rules. We are having rules are there. The form is prescribed form is form number 1. Now let us look at the form number. Okay, so please look at the form number. This is the form number. Okay, so form number 1. Okay, so please look at the form number 1. So application by the financial creditor to initiate corporate insolvency resolution process. Okay, so this is how you are going to make an application to the NCLT. Okay, to the NCLT address from your address. Okay, so hereby sir, madam, we are hereby submit the application to initiate the CIRP process. These details you are supposed to give. Okay, so name of the financial creditor and date of incorporation of financial creditor. So suppose if the financial creditor is a company, then what is the date of incorporation of financial creditor, identification number of the financial creditor, then the address of the register office of the financial creditor. That means I am supposed to give my own details. Okay, then name and address of the person authorized to submit the application. Okay, so Vakalatnama, if any Vakalatnama is there, so who is authorized, then name and address of the person resident in India authorized to accept services, service of process on its behalf. That means someone should be authorized. Suppose take the example, if the financial creditor happens to be non-resident in India, that is resident outside India, then there should be someone who is accepting the any notices, whatever it is. Okay, so anything, if you are sending or if you are serving any notices, someone should be there to accept. Okay, so you have to give the details. Then you have to give the details of particulars of corporate debtor also. Okay, here you are going to give the details of name of the corporate debtor, identification number. So here identification number means SIN number. Okay, so then date of the incorporation. Here you are going to give the SIN number, corporate identification number. Then date of the incorporation, when it was incorporated, and the nominal share capital and the paid up share capital. Okay, or the details of guarantee clauses as per the memorandum. Suppose take the example, if the company is limited by guarantee, then guarantee clauses will be there. If the company is limited by share, then obviously you are going to have the nominal authorized paid up share, nominal share capital and paid up share capital. Okay, then address of the register address of the company, then details of the corporate debtor as per the notification. Okay, assets and income, class of the creditors or amount of the debt, category of the corporate person. Okay, so these things must be given whenever it is applicable. Okay, then part 3 of the application, particulars of the proposed interim resolution professional. As already we have discussed, we have to give the name of the interim resolution professional. Okay, so what is his name, what is the address, mail ID, his registration number. Okay, so please remember, all the insolvency professionals, they are registered with IBBA, so they will be having registration number will be there. Okay, so this registration number must be provided. Okay, then you are supposed to give the financial debt. So please remember the total amount of debt, granted dates of the disbursement. So when the amount is granted to the corporate debtor, when it is disbursed, because that is why it is important. Okay, when it is disbursed, that means it should reach to the corporate debtor. Okay, amount claimed to be in default. Okay, and the date on which the default occurred. Okay, so attach the working for the computation. Okay, so these things. Okay, how much amount is there, what is the default amount. Okay, how much amount you are claiming, everything must be given here. Okay, then part 5. So particulars of financial debts, documents, records, and evidence of the default. Okay, so these things must be given. Okay, particulars of the security held, then particulars of an order of the copy. Okay, these things again we are going to discuss in detail. Okay, record of the default with information utility. So these are all the basic other things to be given. Okay, details of the succession certificate, latest and complete copy of the financial contract reflecting the all amendments and waiver to the date, record of the default. Okay, so all these things you are supposed to give. Okay, so like this you are going to give the declaration, then signature. Okay, so this is how you are going to make an application. Okay, so this is the format in which you are supposed to give. Okay, so this is the standard format, then you are supposed to edit as per your requirement. Okay, so you are supposed to enter the data, then submit the application with the NCLT. Okay, then so I think you are clear with the concept of in the prescribed form number 1. Okay, so you are supposed to make an application in form number 1. Then whenever you are making an application, as already we have discussed, the application under section 7 can be made by individual financial creditor, that is as a singularly or jointly. Okay, so individual application or joint application. Okay, so when you are making an application jointly, we have to consider certain points. Okay, so certain questions can be raised, whether all creditors joining to file application should be financial creditors, because you are saying that you can make a joint application. When I am saying that joint application, does it mean that all the creditors must be financial creditors only? We are going to answer this. Okay, this question you have to answer. Then whether the debts and default due to each creditor must be above the threshold limitation, that is under section 4 of the act. Threshold limitation is minimum 1 crore. Okay, so only if the default amount is more than 1 crore, then only you can file an application. Suppose take the example, I am having 10 creditors. Okay, so together they are filing an application. Does it mean that each and every creditor, they must have given minimum 1 crore, or the default amount is minimum 1 crore? You have to answer this question. Okay, then where the claim of one of the several creditor joining to file an application is barred by the limitation. So please remember, as already we have discussed, okay, for every debt there is a limitation. Okay, generally 3 years limitation will be there. So within 3 years you have to claim. Please remember, one of the fundamental principle in a layman language is that law is not going to protect who is not aware of his rights. So as a person, when you are giving loan, you should be aware of your rights. So if opposite person fails to pay the money, you should immediately react and you should file a case. If you fail to file the case for 3 years, okay, law will presume that you are not aware of your rights. Okay, so we are not going to protect them. Okay, so that is the concept of limitation period. Okay, so if you fail to file the application within the limitation, possibility is there in one scenario. Let us take one scenario. Total 10 creditors are there. Out of the 10 creditors, one creditor amount is already in case of one creditor, already the due date is completed. I mean, it is time barred. Okay, so 3 years is already completed, he cannot file. Now together they wanted to file. Can they file like that? Because 10 creditors are filing the case or application. One of the creditor, his debt is time barred. So can they file joint application? So these are all the 3 things that you have to observe. Okay, issue number 1. So what is the issue number 1? Whether all creditors joining to file application should be financial creditors. So whether all the creditors must be financial creditor? Yes. Okay, in the case of Anil Kumar Jain versus Vardhaman Rollers Mill Private Limited, NCLAT held that financial creditors and operational creditors cannot jointly file an application under Section 7. Why? Because Section 7 is exclusively dealing with financial creditors. So when the section is using the word jointly and the heading is stating that application by the financial creditor, if you look at the section heading, okay, or the title of the section, application by the financial creditor. So that's why here when they are using the word joint application, it means that joint application by the financial creditors, but not by the total categories of creditors, okay, not by all the creditors, okay. So only financial creditors together they can come together, okay. So financial creditor and operational creditor, they cannot file an application under this section jointly. That is not possible, okay. And the second issue, let us go back to the second question mark, okay. So what is the second question mark? Whether the debts and defaults due to each creditor should be above the threshold limitation. That means each and every creditor, whether the debt amount must be minimum of 1 crore rupees, okay. Now the answer is in the case of Vishnu Oil Mills Private Limited versus Union of India, okay, the division bench of Rajasthan High Court held that 2 or more creditors, they have used the word 2 or more creditors, so whose dues do not meet threshold value under section 4 may file a joint application. So what is required is when you are filing a joint application, together you are expected to have minimum 1 crore, okay. So it's not that each and every creditor should have 1 crore rupees, okay. This is the second issue. Then let us go back once again, okay. What is the third issue? Where the claim of one of the several creditors joining to file an application is barred, okay. So whether is it admitted, okay. Try to answer. Let us try to answer. In this case, in the case of Manish Kumar versus Union of India, the Supreme Court held that mere fact that the claim of one out of the several creditors is barred by the limitation should not be a bar to admit the application. So because when you are saying that each and every creditor amount must not be barred by the limitation, then you are adversely affecting the rights of the creditor. So that's why the law is very clear, okay. So merely because one creditor's amount is barred, time barred, it does not mean that he cannot join, okay. So he can join, okay, he can join the application, okay. Now there is a possibility, okay. So application can be made by the financial creditor who is in class. This is recently inserted actually, because home buyers are considered to be financial creditors, okay. So under section 21 subsection 6a clause A and B, two clauses are there. So an application for initiating of CIRP against the CD shall be filed jointly, not less than 100. Suppose if you are making a joint application in case of class financial, in case of class, okay. So it's not general financial creditor, it is about the class of financial creditor, okay. If any class of financial creditor wants to file a case or wants to file an application before the NCLT, then minimum 100 members must be there. Minimum 100 of such creditors shall file an application, or else 10% of the total number of such creditors, okay. So this is useful in case of real estate, okay. In case of real estate, the home buyers are considered to be financial creditor, okay. So recently Supreme Court judgment is there. So Supreme Court stated that home buyers are treated as financial creditors, okay. So that's accordingly this amendment act is there, okay. So home buyers, because they are considered to be financial creditor, if 100 or more home buyers are there, okay, or if they are having 10% of total number of such creditor, okay, 10% of the home buyers, okay, then in such cases they can file a application before the NCLT under this section, okay. So in the case of Manish Kumar versus Union of India, okay, so why it was inserted, okay, section 21 section subsection 6C and clause A and clause B, why it was inserted? Supreme Court in the case of Manish Kumar versus Union of India, they uphold the objectives of the section, okay. So what are all the objectives? So why you are enabling them to file a joint application? To ensure that preventing the multiple individual application, because if you don't allow the joint applications, what will happen? Each and every creditor will file individual application, okay. So it unnecessarily increases the burden on the judiciary. So that's why for preventing the multiple individual applications, okay, this section was inserted, okay. Then safeguarding the interest of hundreds or even thousands of allottees who may oppose the application of single home buyer. Suppose suppose take the example, you are filing a case against one big real estate company individually. Obviously, when you are filing an application for insolvency or liquidation of a big real estate company and you are a small home buyer, obviously the company may say that he is filing application with malafide intention and his application must be rejected. Okay, so that's why to protect interest of such small people, okay, because in case of big infrastructure projects, thousands of allottees can be there. Okay, to protect the interest of these thousands of allottees, okay, they have created this provision whereby they may not be in a position to fight the case individually. Okay, so in such cases together they can form the trust. Okay, this trustee or any authorized person or jointly they can file a case or they can file an application before the NCLT under this act. Okay, so this is the purpose of the legislation. Okay, so this is the purpose why they have inserted through amendment act. Okay, so safeguarding the interest of hundreds or even thousands of allottees. Okay, so this is one of the purpose. Then balancing the interest of the members of the same class subclass. Okay, so because each and every subclass is different. Okay, so if you take the example of home buyers, different categories can be there. Okay, so each and every subclass must be treated separately. Okay, and they should be given protection accordingly. Okay, so because we have to balance the interest, so that's why we are enabling these classes to file the case against the company. Okay, then the process becomes smoother and cost effective, because if each and every person is filing the case individually, obviously legal cost will increase. Okay, so to ensure that legal cost is not increased, to ensure that the process is very smooth, okay, so together they may appoint the trustee and this trustee can file the case on behalf of all these creditors. Okay, so this is one of the reason why they have introduced the concept of application by the financial creditor in a class. Okay, now as already we have discussed previously, whenever you are making an application, there should be a debt and there should be a default. Already we have discussed. Okay, then how to prove that there is a debt and default? Okay, so section 7 subsection 3 provides that an application by FC shall furnish the following. Okay, so whenever you are filing an application before the NCLT, okay, the financial creditor shall furnish the below details. Okay, so record of the default. Okay, so recorded with the information utility or such other record or evidence of default as a case may be. Okay, so whenever there is a default is there, okay, so this record will be forwarded to the information utility. Okay, there is a system called as information utility where you are going to maintain all the data. So you are supposed to give the record of default. Okay, so with the information utility you can extract the data and you can give it along with the application or such other record or evidence of default. Okay, so how will you prove the evidence of default? We are going to discuss. Okay, and the name of the resolution professional, you are supposed to give the name of the resolution professional who is supposed to act as the interim resolution professional, IRP. Then any other information as we have discussed. This is already we have discussed. Now how to provide default? Okay, what is considered to be record of default? Okay, so the record of default includes certified copy of entries. Okay, suppose take the example, I paid some money to the corporate debtor. Imagine I am the banking institution. I gave some loan to the I gave some loan to the corporate debtor. Okay, so there will be an entry in the books of accounts. Okay, so subsequently there should be other opposite entry. If they are repaying, other opposite entry must be there in the books of accounts. So it is missing. Okay, so the certified copy of the entries in the relevant books of accounts that I have paid the money. So what is the evidence that I have paid the money? So there should be bankers books as per the Bankers Books Evidence Act. You can submit the bank statement. Okay, a certified copy of entries in the relevant account of the bankers books. Okay, and please remember when you are submitting the bank statement, it need not be signed. Okay, though the section uses the word certified copy, but as per the Bankers Books Evidence Act, it need not be signed. Okay, so even electronically generated self attestation will be sufficient. Okay, then an order of the court or tribunal that has adjudicated upon the non-payment of the debt. Maybe you have given some money to opposite person, that is the company, as a financial debt, Then he failed to make, that is company failed to make the payment. Then you went to the court of law. Court of law gave the order in your favor, that is in favor of the financial creditor, stating that corporate debtor is liable to make the payment. So court order is there. Okay, so court order is there stating that so and so corporate debtor is liable to pay so and so amount. Okay, so that court order is also one of the evidence. Okay, then please remember, here we have to remember one point where the period of appeal against such order has expired. So if the appeal period is there, you cannot file, because if the appeal period is there is always a possibility opposite person may go to the appeal. So you have to wait till the period of appeal. Okay, expiry of the period of appeal. Then disputed debt and financial debt. So I think you are clear with the concept of debt now. Okay, now let us discuss disputed debt and financial debt. Now there are two categories of debts: disputed debt and financial debt. So in case of financial debtor, okay, financial creditor, financial debt must be there. Okay, so whether the debt is disputed or not, because when you are raising the point or when you are claiming money from the company stating that you owe me so and so, you are supposed to pay so and so, as a financial creditor you are filing an application, then he may raise a dispute. So will it be important? Okay, so the Supreme Court in the case of Innovative Industries versus ICICI Bank, this is one of the landmark judgment you are supposed to remember. Okay, Innovative Industries versus ICICI Bank, the Supreme Court observed that disputed debt is not relevant in case of application by FC. Okay, though it is relevant in case of application by the OC. Okay, when this OC, okay, so when operational creditor is filing an application, okay, under the IBC, okay, so whenever there is a disputed debt is there, then you cannot file an application. Okay, so in the subsequent lessons we are going to discuss the essential conditions to be satisfied when operational creditor wants to file a case. Okay, so the disputed debt is relevant in case of operational creditor. Okay, so when any disputed debt is there, operational creditor cannot file an application, but this is not relevant in case of financial creditor. So in case of financial creditor, existence of the debt is sufficient. Okay, so existence of the debt is sufficient. Okay, whether that is disputed or not, this is not relevant. Okay, so disputed debt is not a bar, okay, to the admission of an application under section 7. Okay, it was held in the case of Vineet Khosla versus Edelweiss Assistant Restructuring Asset Reconstruction Company Limited. Okay, so in this case la NCLAT, National Company Law Appellate Tribunal, held that so disputed debt is not a bar to the admission of an application under section 7. Okay, so even though you are having disputed debt is there, you can file an application under section 7, but you cannot file an application under 8 and 9. That is not possible. Okay, then disposal of application within 14 days from the date of initiation. So if you look at section 7 subsection 4, clearly we have discussed the section already, so which clearly says that the NCLT shall, okay, within 14 days they have to accept the application or else they have to reject the application. Okay, so whenever they are exceeding, they have to give the explanation. Okay, now when the section or when the legislation uses the word shall, so does it mean that it is really a shall, or we have to interpret it as a may? Because there is a difference is there between the shall and may. Okay, so the question mark is that whether you have to interpret it as a shall, whether you have to interpret it as a may. So it was clarified. Okay, so NCLT need to ascertain the existence of default. Okay, whether there is a default is there or not, you have to ascertain within 14 days. There is a time limitation. Okay, now if the NCLT is unable to ascertain within the time limitation, so within the time limitation you are unable to ascertain whether there is a default is there or not, then NCLT required to record the reasons. Okay, why they are unable to, maybe because of lack of availability of the records. Okay, maybe the application is not supported by the sufficient data. Maybe in the information utility, at information utility you don't have the proper data. Okay, so data is not available. Then in such cases you are supposed to give the reasons. Okay, now in the case of by the Supreme Court, in the case of Surendra Trading Company versus Juglilal Jute Mills Company Limited. Okay, so the Supreme Court held that though the section uses the word shall, okay, but it is directory in nature. The Supreme Court stated that it is directory in nature. So that means it is only may. You cannot interpret it as a shall. You have to interpret the section as may. Okay. So whether discretion is available or not? Yes, already it is proved that discretion is available. Okay, so under section 7 subsection 5 of the act, tribunal may accept or reject the application. Tribunal is having the freedom whether to accept the application or reject the application. Okay, and here if you are looking at the 14 days, okay, so within 14 days they may not give the decision. So there are 2 points. Okay, you are having an option to either accept the admit the application or reject the application. That is one point. Okay, this admission of application and rejection of application must be given within 14 days. That is another point you have to consider. Okay, so both are different. Okay, so in the previous slide I am talking about within 14 days you have to intimate. So when you are admitting or rejecting, as per the section you are supposed to intimate within 14 days. But that is 14 days is discretionary in nature. That is only directory. That means you may take more time. Practically majority of the cases, application, accepting the application itself may take minimum of 6 months. Okay, so there is a practical reality. Okay, because of so many reasons. Okay, so once it is admitted, okay, so whether are you having a freedom to admit or reject? So is it whether discretionary powers are there to the NCLT, whether to admit or reject the application? We are going to discuss. Okay, so under section 7 subsection 5, the tribunal may accept or reject the application. Here there is a discretionary powers is there. Okay, it is here the word may shall be interpreted as may only. Okay, so in the previous slide the word shall be interpreted as may. So I think I am clear. Okay, so in the previous slide we have the section uses the word shall. There the word shall be interpreted as may. In the present slide the word used is may. The section uses the word may. Here may has to be or shall be interpreted as may only. It cannot be shall. Okay, so the tribunal may accept or reject the application. Okay, so whenever they wanted to reject, okay, if there are any defects are there, okay, then the tribunal shall give an opportunity to rectify the application. Okay, so when financial creditor is making an application, if there are any discrepancies, some defects are there, then in such cases the tribunal shall give tribunal shall give an opportunity to the applicant. Okay, then SC Supreme Court in the case of Vidarbha Industries Power Limited versus Axis Bank. Okay, so in the legislation the word used is may. Okay, so here they are interpreting may as may only. Okay, the NCLT can exercise discretionary powers based on the relevant facts and circumstances. Okay, so because they have the legislation itself is giving the discretionary powers, so NCLT is having discretionary power. Okay, based on the relevant facts they have to verify. There is a checklist is there. Okay, so whether there is a debt is there, whether there is a default is there, okay, evidence is there, whether resolution professional is appointed or not, I mean proposed or not, whether is there any disciplinary proceedings are there against him. So all this checklist they have to observe. Okay, after observing everything, okay, it is up to the discretion. Okay, so if the NCLT is of the opinion that this case or this application is filed before the NCLT only to unnecessarily trouble the corporate debtor, possibility is there. Okay, so unnecessarily create problems to the corporate debtor, maybe one of the financial creditor is filing an application. Okay, so if that is the case, NCLT may reject. Okay, so that's why there is a discretionary powers is there, powers are there where NCLT, depending on the relevant facts and circumstances, they are supposed to decide. Okay, in the case of Deepak Veg Pro Private Limited, Sri Hari Agro Industries Limited. Okay, so NCLAT held that NCLT is mandated to exercise a discretion to dismiss the application. Okay, so whenever if NCLT wants to reject the application, they have to use the discretionary power very carefully. Okay, because if you are rejecting without proper grounds, you are affecting the rights of the financial creditor. Okay, so that's why you have to exercise your discretion properly. Okay, so mere change in the management, okay, is it a ground for dismissal of the application? No. Okay, so suppose take the example when you are filing an application as a financial creditor, you are filing an application against a corporate debtor. Meanwhile, there is a change is there in the management, maybe because of the takeover, some other reasons. Okay, so does it mean that you are not entitled to file an application? No. Okay, so mere change in the management is not a ground for dismissal of application under section 7 of the Act. Let us recap what we have discussed today. In today's lesson, we have discussed the initiation of CRP by the financial creditor, how to initiate the CRP by the financial creditor, we have discussed. Then application by the financial creditor in class, we have discussed. Then we have discussed about the evidence of debt and default. So how to prove the debt and how to prove the default, we have discussed. Then we have discussed about the disputed debt and financial debt. Then we have discussed about the disposal of application within 14 days from the date of initiation. That means once the application is made by the financial creditor before the adjudicating authority, then the adjudicating authority is expected to dispose of the application within 14 days. Then we have discussed about the discretion available under section 7 subsection 5 to admit or reject the application under section 7. So where we have discussed once the application is made by the financial creditor, whether the adjudicating authority is having any discretionary powers or not. If he is having discretionary powers, to what extent he is having discretionary powers, when to admit the application and when to reject the application, we have discussed in this lesson.
Thank you.